Well, thank you so much, everyone, for joining. We have Sarah Schickman here with us today. Sarah has really been functioning for more than the last year with this business of aesthetics community as a resident expert for us, a legal expert. Uh, I love that Sarah has not seemingly backed away from anything. It's not, I don't see her giving advice with disclaimers and, oh, I'm not in your state, so you should. She may say check with someone local in your state or this or that, but really you've confronted everything that's been asked of you head on. And I think it's so refreshing because so often we get advice, but it's like, but I can't really advise you anyway. So you seem to uh be have that confidence to share with us, and it's such a benefit to our community. So Sarah's been functioning in that way. Also, uh, has been a huge part of our groups, our Facebook group and our LinkedIn group. I know just a couple of days ago, and I thought maybe, Sarah, this is where we could start, but there was a post that says, what legal questions would you want Sarah Schickman, managing partner at Lengia Law, to address for your Medspa? And there's like an overwhelming amount of questions. And then we asked attendees also. So if you're okay with it in the style of really how you've been helping our community, I thought we could just jump in and go and answer some of these questions. Some of them you and I have talked about, so I know they're kind of come up a lot and maybe we need to re-answer them, but some things I haven't seen before either. So, and I know one of those responses about 6 or 7 days ago on the Facebook group was by me. And I put a question in there because I want to know the answer. In our clinic right now, we're kind of in the situation. So, Sarah, long-winded entry, but thank you for joining us. Anything else I missed about you, please say, and then we'll get started.
No, thank you. That was a great introduction. It's my pleasure to be here. As you mentioned, I like answering questions directly, as directly as I can for a lawyer, right? People come to us because they want answers, not because they want some long, convoluted explanation that doesn't really help them. So if I know the answer, I'm always happy to give it to someone. And the level of questions that we're getting in the Facebook group is really impressive because people are dealing with really high level problems, and it's fun to answer the question. So it gives me great pleasure to do this webinar and to participate in the community and just to have the answers to hopefully help everyone and help their businesses.
Well, let's pay homage to this Facebook group, which if you're not a part of, if you join this webinar and you're not a part of the Facebook group, it's only a couple of questions to make sure that you're a real person and that, that you're somebody that we want to join our group, because it is a private group, but we have something like close to 6,000 people now. They're really active. They participate. When someone asks questions, not only Sarah answers, but other people answer with their individual expertise, or so a lot of business questions, management questions, not always legal questions. I will say, if it is a legal question, I'm listening to Sarah or another lawyer and not necessarily a colleague. But we all have so much unique experience, and that's the benefit of the group. So let me start with this. And Sarah, I'm thinking maybe we can more rapid fire because I want to get through a lot of different topics. We may not get super in depth in any topics, but people can follow up with you.
Yeah, definitely. We can answer as many questions as we can. And if people have other questions, they could always go to our website, which is lengialaw.com, and schedule a free consultation with us. Or if they're already clients, just schedule a time to talk. So yeah, let's get to it. I'm excited.
All right. So this is from a Dr. Pirani. This says legal steps to take when hiring or firing someone. Kind of broad.
Yeah. So generally what I would recommend is having paperwork in place. So first, having screening paperwork. So having somebody fill out some kind of employment application where they have to list where they've worked and where they live and who they are. and then doing background screening on them. There are third-party companies that do it. One is called IntegraScan. It's under $50, I think. So I would say doing the screening on the people, having them fill out an employment application, and then making sure that you have a contract with them. Whether they're a contractor, whether they're part-time, full-time employee, whether they're your boss or your secretary, everyone should have a contract. And then once you have more than one person on your team, I think everyone should have some kind of employee manual or team member handbook or some sort of policy and procedure document. And in that document should be a list of what someone has to do a great job. And included in that first kind of employment contract, they should have a job description so they know what their job entails. And then in this handbook, you would also have a policy for progressive discipline. And so if you need to fire someone, you would follow that policy so that they can't complain that you were discriminating or that you did something improperly. So it's very important to have this discipline policy, follow that policy, and when firing someone, have documentation as well. So if you give them a warning, make sure to write it down, document it in their file. If an employee comes to you complaining about another employee, make sure to document that, write that in the file. So I would say, and the saying is very true, you have to hire slowly and fire quickly. If someone is really not a good fit for your practice, it's better to get rid of them because usually that bad behavior just continues. It doesn't usually get better. So I always tell my clients, even though it may be hard, it's easier to just cut the cord and move on than keep trying and trying and trying and then be at the same place.
And the school of, I'm a small company, the more documentation I have, the more I'm holding myself accountable. I shouldn't create a employee policy and procedures manual. It just your 2 seconds on that.
I think that's old school thinking. It is terrible advice. It is 100% wrong. I have so many clients, like I have a couple of doctor clients who in their fellowship or residency or in their first job, they were told, you know, you don't want to have any paperwork. It's just like, it's even worse. And I insisted on them having good paperwork with their employees. And now if there's an employee issue, it's very clear. There are very good contracts. There are arbitration agreements. It's much, much better than what would happen if there wasn't anything like that. So I think that advice is terrible.
And I don't have time to do this. I don't know what to do. Can I go buy something that makes sense? Or is there, because let's say you work with so many med spas, is there some more boilerplate?
Yeah, good question. So as part of what we do, we have a membership that includes a bunch of templates. So you could use something like off the shelf that we put together, from an employee handbook to a contract for a contractor or an employee. But as you get a little bit bigger, we do recommend customizing it to your state and your practice. So I would say if you're tiny and you really are on a very, very low budget, yes, you could use a template. But if you're really, I would say I would use a marker like this. If you're expected to do gross revenue of 500,000 a year, you should have a real lawyer draft custom documents for you.
And even when I look at the cost of that, I think I'm looking at 1 or 2% of my gross. I'm not looking at huge amounts of.
Exactly. Like I would say, let's say that your legal costs would be 5,000 to 7,000 a year. It's like 1% of revenue. It's really worth it because one legal problem is 10, 20 times that. And they do happen.
Yeah. This is from Joy King. Leasing rooms and liability of other providers in your space and how to structure things like that.
Yeah, that's a great question. Leasing rooms from other providers and to other providers has a lot of potential issues, but it's also a great way to start if you're starting small. So one way to protect yourself, if you're the landlord, have really strong contracts where you're basically not making it as a lease, where you're not creating a landlord and tenant relationship, because that gives the tenant a lot of rights. Make it like a membership agreement or a licensing agreement or some other kind of agreement that's not a lease. And that way you don't have to give as much stuff to the tenant. But if we're advising the tenant, I would say you should get a sublease agreement. It should be as specific as possible so they can't kick you out. And then also have some kind of indemnity there. Because what happens in these sublease situations is a client comes in and they have some issue if there's a problem, they're going to sue everyone. Whether you're the landlord, whether they're subleasing from you, the client is not going to care. And then it's going to be up to you to try to prove that it has nothing to do with you. So you want to be protected from that. You want to require that your tenants have insurance. So I think there are a lot of potential issues with this structure, but at the same time, I think it could really work if you have the right paperwork.
I have had a few questions about this. I'm gonna read them kind of together. Dr. Jasani says, management services agreement specifically regarding verbiage related to payment of doctor and limiting access to bank accounts. I'm not sure exactly, and then someone else put how to form an MSO. What does an MSA entail? So I actually don't know the difference between an MSO and an MSA, or if that was a typo, but it seems like I've heard both. So can you talk about MSOs in general? I've heard of it.
Yeah, definitely. So there are two different types of states. There are states that prohibit what's called the corporate practice of medicine, and there are states that don't. In the states that prohibit the corporate practice of medicine, and that's the majority of all the states, only a doctor, or in some states, a full practice authority nurse practitioner can own a medical practice. So in those states, like New York, for example, you can't just, if you're not a doctor or a full practice authority nurse practitioner, you can't just open a medical spa. What you can do is open what's called a management company, an MSO. What that stands for is Management Services Organization. And that's a fancy way of saying it's a very special kind of LLC. So the MSO is the special kind of LLC that's owned by the non-doctor or non-full practice authority nurse practitioner. That's one side of it. Then there's the practice entity, which is the medical company that's owned by the medical director. And between those two companies, there's the contract, which is the MSA, the Management Services Agreement. So in every state that prohibits the corporate practice of medicine, you generally need this structure where we would create the MSO for you. And then there would be a contract between your MSO and the doctor's company. And that contract is called the MSA.
Terrific. And I'm guessing that's something you deal a lot with, putting those types of agreements together.
Yeah, we do, I don't know, at least 20 a week, probably, maybe even more. So yes, that's something that we do a lot of, and they could be customized many different ways. Again, depending on whether we're representing the practice or the doctor, or whether we're representing the, let's say, the registered nurse or the business person who owns the MSO. The contract could be very, very different. And so we see who our client is and how we can customize it to really fit their needs. So for example, if our client is the medical director, we would make sure that things like them getting paid are really clearly spelled out, that they are indemnified as much as possible, that they have really clear scope of duties and things that they're not responsible for. And then if we're representing the MSO, it would be a very different kind of contract. So a lot of times what happens is people come to us and they may have a template from somewhere, from like a company that provided the doctor to them, or a company that, somebody else they knew they used before 10 years ago, but the contract is not favorable to them and the template actually makes the situation worse. So this one particular contract, I would say never use a template, always get it customized.
Yeah, and I would think too that how money is, there's taxable ramifications to all that stuff too.
Yeah, definitely. And money is what people in these situations tend to fight over. So we want to make sure that the way the money is handled and the payment priority in these contracts and who has access to what, like the bank account, is really clearly spelled out. But it also really depends, again, on who our client is, because it could be two very different contracts.
And then the state by state, like I'm looking at one of these questions says, this happens to be an Idaho person, but says paying medical staff commission in Idaho is that fee splitting. I don't expect you to have that on the cusp of your fingertips with Idaho and what kind of state they are, but it's the same idea, which is there a way to compensate people for generating more revenue? Yes, I'm sure there is. Is paying commission fee split or not? That's a great question, and everyone should be asking that in their state if they don't already know the answer.
Yeah, definitely. And I think the laws in each state vary with respect to how strict the definition of commission is and what it means, what fee splitting really means. The federal anti-kickback statute really only applies when you're talking about government insurance and when you have patients that have Medicaid, Medicare, and things like that. But every state has its own version of this. And in many states, just paying people like no base salary, just a straight, let's say 20% commission off of their services would be considered fee splitting and would not be allowed.
So we're jumping around. So I'm going to jump to another thing. And this actually sounds, this is Dr. Danielle Causey, but Dr. Danielle, it sounds like you named another podcast for us, but it's top 10. So I'm not expecting 10 here, but top 10 must-haves in your new patient intake forms. So maybe just general ideas about intake forms.
Yeah, I don't know if I could just recite 10 off the top of my head, but I was just working on some intake forms today. So I would say the things that you may not think about having in them. I would have a section about text messages about appointments where the client would specifically consent to text messages, because technically text messages need their own separate consent section. I would have a section about financial responsibility, and that whatever your payment policy is, no refunds or whatever you have, put that in the consent as well. So they could never say, I didn't see it on your website, it wasn't on my receipt, that kind of stuff. I would also make sure that there are always these new kind of adverse effects that are coming out, especially with newer treatments like semaglutide. So if you hear of like something new, or your attorney tells you, okay, you need to update your consents, just make sure you keep them updated to whatever the newest side effects that are being discovered are. And then the other thing that's really important about consents is they have to be signed before the treatment, and the patient has to, in the consent, make sure that they say that they read, speak, understand English, because sometimes people come back and they say, well, I don't speak English. And the other thing is, if the patient is a minor, just make sure you get their parental consent as well every time they get treated, especially for more high-risk things like laser hair removal.
Do I need the kid's signature also, or just the parent signature is the kid's signature?
Good question. I don't know off the top of my head. I think a kid generally cannot fully consent. So their parent's signature is the signature. But I think that it's probably good practice to have the kid's consent too. Or the kid's signature. So I would have both.
And this is another old school thing, so I'm probably dating myself, but do I need someone to witness me asking? They used to say you need someone else in the room too when you go through the consent process, but I've heard you don't as much.
I don't think so. At least in the states that I'm very, very familiar with off the top of my head, I don't think that you need a witness on the consent.
Okay. You mentioned semaglutide, and there's a couple of questions about legally advertising or using generic compound for semaglutide. And I know all of my semaglutide info has been coming from you because you follow all the lawsuits and what's happening around the country.
Yeah, semaglutide. I was just talking to someone about it just before this webinar. Yes, you cannot, for any drug or anything, actually advertise one thing and sell a different thing. That's false advertising. That's usually trademark infringement. So there are a lot of possible claims that the manufacturers could have against you. What happens practically is, if the drug is not a high priority for the manufacturer, or if it's not a big money maker and they're not like losing tons of money by you doing whatever it is that you're doing, a lot of the times they may not come after you. Like one example of that may be Kybella, for example. A lot of people do PCDC and other things. technically, if you're advertising Kybella and you're doing this other thing, this is the same issue as with, semaglutide and Wegovy or whatever. But Allergan is not really coming after people because that's not their blockbuster drug, right? But here, what's happening is the pharmaceutical companies are losing a lot of money because people are doing generic stuff. So they're trying to find any kind of hook for people advertising. So just make sure to get your advertising reviewed by a lawyer or someone who really knows this area really well, and make sure that you're not advertising anything generic as the brand name, or even saying something like, well, works as well as Manjaro,
Whatever. But I mean,
Ozempic.
can you say semaglutide?
Yes, you can say semaglutide. And you should probably say somewhere that you're using the compounded version of semaglutide. But I think you can say semaglutide because semaglutide is not the trademark term.
Right.
You're not saying something else. But even if you're saying semaglutide, I would say, to, in the abundance of caution, to also somewhere mention that it's a compounded version, that it's not FDA approved for this particular thing. But I think as the market shifts and as more people are entering this space in terms of selling semaglutide, the prices of it have come down in terms of the margins that people are charging, because there's always some new person that's doing it for 300 a month or 200 a month or whatever that people are doing now. So I think as the profitability of semaglutide is going down, people are being less, I would say, less aggressive and spending less money on the marketing because they're realizing, okay, like maybe this is a more of a short-term thing versus a long-term thing.
I think semaglutide in and of itself is gaining momentum, the name. So the generic has become somewhat branded.
Yeah,
People
definitely.
don't have to say Ozempic anymore. They're like, or Wegovy or whatever.
Yeah, definitely. And I think when they do that, they just have to be careful, like with the whole not being FDA approved exactly for what they're doing. And then just being careful of everything that they do, and the compounding pharmacy that they're buying it from, and then not transporting it over state lines. Because I know sometimes some of the states, some pharmacies have stopped shipping it, let's say to California. So people are shipping it to Texas and then moving it themselves from Texas to California. Technically, that's against the law and you can get into a lot of trouble. So just have to be careful.
Yeah, just as a lifelong business owner, living in the gray catches up with you at some point. If the, you can't have gray, it will catch up with you. That's why I like what you said with the employee policy and procedure manual. It was like, that's the old school way to do it because you need documentation. And also, I a doctor you used to work with, I know you helped formulate, they grew like 15 locations or something, but Justin Harper said to me one time, I like having policies because it means I don't have to point the finger. I don't have to blame anyone. We can just go look at the policy. And it was just an astute way to look at things, to say, it's not like, hey, you messed up. It's like, hey, this policy may need to be rewritten or maybe not, or
Yeah, and your policy and procedure document is a living document. You could always update it. So of course, people always come up with new things, right? We had a situation where someone had a great employee handbook, but one day that their practitioner started coming in with like a shirt that on and their dress code just said all black, whatever. And on her shirt, she would have like a little logo of her new Instagram page of her new Medspa that she's starting. Of course, that wasn't in the employee handbook because like you can't really account for every situation. But once that happened to them, they're like, okay, we're going to add this to our policy and procedure manual. So it's even when you have one, sometimes it's not perfect or it's impossible to account for every situation. But yeah, I agree with Justin. Like if it's in the book, it's not me saying this to you, singling you out. It's in the policy and procedures, which by the way, you signed.
and meanwhile, if the employee comes in with a hashtag of their future business, I think there's no more cry for I want another job. I'm ready to leave. So call Sarah because she won't cherry coat that one, or call me. We'll tell you exactly what that means right away. That's
Yeah,
one of those, I'm not gonna sit around and wait for 90 days because the poison is already in the well.
exactly.
And probably you've documented other misbehaviors in the last whatever month, and and depending on what state you're in, a lot of them are employee rights, employers have the right to hire and fire at will, so you don't need reason necessarily.
Mhm.
Is there a resource guide for med spa compliance laws?
Yes, your local law firm. Yeah. So there isn't, the reason there isn't like a resource guide is because the laws are constantly changing. So even for ourselves, we we have a team of 10, and one of our people, his full-time job is basically scouring all the new laws that are happening and digesting them and then updating our internal resources to make sure we're up to date for all the states. So there isn't a guide that you could buy today because tomorrow it may be outdated. But you would just call your lawyer and say, okay, this is what I'm doing. These are the treatments that I'm doing. This is how my med spa is owned. What are the applicable compliance things? And they can tell you.
So this came in as we were talking about semaglutide, and I didn't see it, but I want to just ask because this person says, but isn't semaglutide FDA approved? And I want to just go through that a little bit because I think people get confused as to uh, a clearance or an approval, and um, being passed by the FDA versus being approved for something specific.
Right. So when something is FDA approved, the next question is FDA approved for what? So yes, semaglutide as a compound is FDA approved, but it's not approved for weight loss. So because of that, you can't say in the context of what we're doing, you can't say that semaglutide is FDA approved. That would be misleading. So, and then you would say, well, who cares? Like, who's going to come after me for that? And the person that would come after you for that would be the FDA. And every time you deal with some federal agency that could come after you, the possibilities of what can happen are much, much worse. Because unlike state medical boards or nursing boards or cosmetology boards, it's not like your local person or they're understaffed or they have a limited number of people and budget. The FDA can put 100 people on your matter and they will find something once they're looking. So it's just important whenever it comes to FDA issues to be like super, super compliant.
Uh, I don't know how to approach some of these, but maybe I'll just ask you a few of them because there's a lot of like state specific questions, and this is, I don't love to do this stuff live because not everyone here is in South Carolina or where some of these other coming from. I saw a North Dakota, I see. So yeah, I guess I mean, like this one, I guess maybe you answered this already, but this one says partnering with a doctor in Kansas. There are no definite laws here. Any advice? I think
So
that's what a lot of people are kind of finding. Or how do you deal with California non-compete laws? Or South Carolina, are medical directors paid? Do they need to be paid in-house or another way? Those are the kinds of state specific. I saw one other one, Michigan laws for RNs and estheticians.
okay. Well, I mean, I can answer some of those just because I know the answer. But yes, every state is different, and the med spa laws generally are state specific. And we as a law firm cover many states, but generally speaking, like the first question is, does your state prohibit the corporate practice of medicine? So states like Kansas, Texas, California, many other states, right? And so in those states, you need this MSO MSA structure. That's the first thing you're going to need. So you hire a law firm to set up an MSO for you, and then the MSA agreement. And then your medical treatments and your medical staff have the revenue from the medical treatment has to go into the medical account first. So imagine there are two companies. One is your MSO and one is the medical director's company. To be fully compliant, the revenue would have to go into the medical director's company account first. And then from there, all the medical staff would be paid, including the medical director. So that's how the setup would have to work in every state that prohibits the corporate practice of medicine. And then in terms of scope of practice, every state is very, very different. Like what an esthetician can do in Michigan is very different from what an esthetician can do in New Jersey or Texas or Florida. So what we typically do is our clients send us a list of what they're trying to do, what services they want to offer, and who they want to do them. And we say, yes, you can do it. No, you can't do it. This is high risk. This is low risk. This is low enforcement. This is high enforcement. So, there's some gray areas for sure. And with some gray areas, some people choose to take the risk. And with some gray areas, though, the risk is just not worth it. So what we do is we just advise people like, this in this state, if you're an esthetician and you're going to try to do laser hair removal, like this is super high risk. You are going to get in trouble. It's going to be really bad. In some other states like New York, an esthetician can do laser hair removal, no problem.
How about telehealth, and I guess with Zoom too? And I was actually thinking about this, like, I know a lot of people in New Jersey go to New York for services. If I'm only licensed in New York, can I do telehealth in Jersey? Or if I'm in one state, can I manage someone semaglutide or something in another state, or do I need to be licensed in that state?
You need to be licensed in the state where your patients are. During COVID, there were a lot of exceptions to this because it was an emergency, and a lot of states issued different advisory opinions saying that for now we're going to be flexible. So if you're in Pennsylvania, but the client is in Florida, whatever, you can do it for now. But now pretty much in every state, you have to be licensed in the state where the patient is. So technically speaking, unless it's really an emergency, if let's say your patient went from Florida to Texas and you're not licensed in Texas, you're not allowed to prescribe to Texas.
Okay. But if I've already prescribed and they're local and then they go to Texas for like a month, can I do telemedicine with them, or not? Theoretically, not when they're in that state. They should be back in their home state.
Yeah, there are some exceptions, and depending on the state, I don't remember off the top of my head how flexible Texas is and what the time periods are, but it's very state specific. So technically, for most states, it has to be an emergency kind of situation. Otherwise, they should really be seeing someone local.
Okay. We're spending all this time talking about all these exposures. This is a pretty great question. How common are med spa malpractice lawsuits?
This is a great question. I'm so thankful that someone asked. Med spa malpractice lawsuits are not common. If someone tells you that they are common or tries to scare you into something by saying that, they're not telling you the truth. And the evidence for that is med spa insurance rates for med spa malpractice are really low compared to like gynecology or even regular internal medicine, right? So the insurance companies are not stupid. They would have higher rates if they had higher claims. So med spa malpractice claims are pretty low, and I would say 70% or more have to do with more permanent treatments like laser hair removal. Not to say that laser hair removal is permanent, but possible scarring from laser hair removal is permanent. So with Botox, it wears off. With filler, if you have Hylenex, you could make it go away. But some of these things that once somebody has it, there's nothing you can do to make it better, or there's something you can do, but it's never going to make it 100% better. That's where most of the malpractice cases are. And a lot of the malpractice cases that we see are also have to do with the patient not feeling like they were taken care of, like the practice didn't offer them a refund or to see them. And I could see why they may have not done that. But a lot of malpractice cases in this space are avoidable. And what we try to help our clients do is like really mitigate them. And we talk to the patients and try to reach some sort of settlement amount before a malpractice claim. So their insurance doesn't go up, they don't have to pay a lot of money, and everyone is happy.
I mean, it having worked in underwriting or with underwriters for many years, helping them come up with policy and trying to make sure it was real and not perceived, you know. I have to say, it seems like a lot of the actual malpractice lawsuits came down to hurt feelings.
Yeah, definitely. Or really blatant violations of standards of care. Like a lot of times, like if in the Medspa situation, if you have a patient death like that happened in Texas, well, it seems like that person never had a good faith exam. The Medspa wasn't properly staffed. And of course, it happened to be that this patient, probably what we call in the legal field, was kind of like an eggshell plaintiff. Like they probably themselves already had some underlying medical issues that weren't discovered. So no one should die from IV hydration. But I think those things happen, but very rarely in this space. What tends to happen is like what you said, the patient feels abandoned. They feel like they weren't respected, even if the practice was super nice to them. But it comes down to really trying to mitigate the damages before it blows out of proportion. Before, sometimes we have to put our egos aside and our beliefs aside and just be like, okay, I know on principle I don't agree with this person, but if a $2,000 check is going to make this problem that's causing me 10 sleepless nights already go away, maybe it's worth it.
That, I mean, one of my favorite things, and I apply it in so many times, so many different places in life, is do you, do you want to get what you want, or do you want to be right? Because a lot of times it's like, you can be right, you can stick with principle because you're right and you know you're right. But if you want to get what you want, you may concede that you're right to get what you want. And if you want to dig your feet in and stand on principle, that's right. That's your prerogative as well. But if you want to get what you want, you may have to undig your feet.
Yeah. Yeah. As a lawyer, clients call us and they say, well, I want to fight this client, to the death. Like send them a cease and desist letter, sue them. And I'm like, well, I'm not your accountant, but I always as a small business owner myself, I'm like, look, we're going to spend $10,000 for you to make a $3,000 problem go away. Why don't you just pay them their $3,000? Even though on principle, I know you disagree.
Yeah. And then they say, no, I don't care. I still will do it for $10,000. And then a couple of days later, things probably are calmed down a little bit more.
Yeah.
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 You said it, and my next question. So we are either on the same plane or we've done lots of these together, but what are the must include items for a good faith exam?
Okay, good question. It depends on what type of treatment the good faith exam is for. So the good faith exam ideally should be specific to the treatments that you're looking to prescribe. So the things that you'll ask about or ask the patient to fill in will be different for, let's say, cool sculpting than IV hydration, right? So, but just basic stuff about a good faith exam is you want to take the patient's history. You want to see if they have any allergies. You want to talk about their past procedures and what's bothering them. And you want to make sure that the good faith exam, and this is very important, is done by the appropriate level provider. In every state that I can think of, a good faith exam, unfortunately, cannot be done by an RN or an LPN or an esthetician or by me or by Jeff. It has to be done by a nurse practitioner, a physician assistant, or an MD in most states. So the most important thing about a good faith exam is that it's done by the right level of provider, and that it's in writing, and that it's documented, and that it happens before the treatment. You can't really do a good faith exam after the treatment has been performed. It's not going to be a real valid good faith exam.
Yeah, and when you have an intake process, it needs to be very clear. And when that's done, it's also, it's like, before and after pictures. There's only one chance that you have to get a before picture. And
Yeah.
if you haven't documented it, it's not part of your intake process and you miss it, you missed it.
Yeah, and we have a template that we give to our clients for good faith exams that's very comprehensive. That's for many different types of treatments. But the good faith exam is your one opportunity to write down, what the client wants, what their contraindications are. If you don't have that, like you can't really go back and make it later. It's not really going to be good enough.
I have an anonymous question and also Ivy Cleveland about franchising. The anonymous one says, if you're new, first time opening a med spa business, what are the pros and cons? Should I look into the franchising?
Well,
Seems like a
I
business question too, but I guess maybe coming from a legal
Yeah,
perspective.
and I think both of us can answer it. I can answer it first, and then maybe you can answer it because you could offer a different perspective. So the question, as I understand it, is, does it make sense to buy into a franchise or open a med spa on your own? So I wrote a book. It's called Med Spa Confidential, which you could buy on Amazon, and it talks about starting small and starting a med spa like by yourself in a single room and how to do it. And I wrote that together with one of my clients and friends. Name is Dr. Carol Clinton, who's awesome. And she started her practice from like a very small location and then sold it for a really great amount of money. And it was an independent practice. That being said, that's one way of starting a practice. And if you have a very, very limited budget, and you want to get into the industry for, let's say, under $100,000 or $50,000, then you could start small on your own and see how it goes. And we have a lot of clients who started that way and now are very successful. So I'm all about the small business and helping people start small. At the same time, the franchise companies give you so many great resources and they have the experience and they give you this backbone support that you don't get when you're starting on your own. Sure, I, as your lawyer and your business consultants, will be able to help you, definitely. But your franchise people usually are going to be the ones you call like all the time, and they're going to give you all the best practices for everything for your business. So what you're talking about there, though, is usually an upfront investment, including the required build out and stuff like that, of at least $200,000 to $500,000, and many times more. So it really depends on what you're looking to do and how you're looking to start. And then at the same time, just realize that franchise is a commitment. It's like getting married. You're signing that contract and you're agreeing to that royalty till, death do you part. So if you're not happy with the franchise agreement, they are very, very tough to get out of. So just make sure that you really do your due diligence and you talk to multiple franchise companies. And there are some really good ones in this space.
And do I bring that contract to you to help me determine whether it's a good franchise agreement or?
So a lot of these contracts, which are called FDD, are not really negotiable or not really highly negotiable. So yes, you could bring it to me, but expect that a lot of the provisions there are not going to be able to be super negotiated because they
Right.
use one form.
I'd bring it to you to help me understand the contract,
Mhm.
not necessarily to negotiate.
Yeah. Or to give you an opinion, like, do we think that this is a good franchise? Should you talk to a different franchise? Since we have done so many franchise deals, we could tell you that. But I think that you can go both ways.
Yeah. Yeah, and I agree with everything you said. I don't have really an opinion on it. Are you the kind of person that likes to own your own stuff? Do you want to, go to work and go home at the end of the day and not worry about all the minutia, or are you a 24/7 worker anyway and you don't want to give away a bunch of percentage? I've made so many mistakes over decades in business. It's like, would I pay to not make some? I mean, I paid either way. So, but I
Yeah.
don't know if I had to do it again. I don't think I would franchise, but I certainly can see it, especially if I really want to practice. If I'm a provider and not a business person, I'm more of a business person, not a right. But if I'm a provider, I think, yeah, maybe the idea of having a business partner is really appealing to me because then I can go in and provide medicine. If you're a provider of medicine and you're opening something for yourself, you are going to become a business person. You have no choice, or you're going to fail.
Mm-hmm.
Uh, this question came in, actually here, there was one we were already talking about that came in through this, on the good faith exam, just a quick follow-up. Can a nurse prac do a good faith visit, via telehealth? So I guess,
Depend
can a provider that's allowed to do good faith exams do it via telehealth?
Depending on the state, most states do allow telehealth, and also depending on what you're going to prescribe. So right now, there's a period where even if you're going to be prescribing controlled substances until December of 2024, you're allowed to do it by telemedicine. So even if you're prescribing things like testosterone, ketamine, other things like that, you can do a virtual good faith exam, but that's scheduled to change. So that will depend on what your specific state laws are, which we could check for you, and then also what you're prescribing.
Uh, this is a great question. I'm interested in this too. We've all been, people are doing more and more of those memberships or like VIP programs. I've seen a bunch of them, like some of them are discounts. Some of them are like you prepay and you get certain amount towards, I don't know, I've seen things in tiers. I guess I really don't have specific examples, but I know, Sarah, you've seen a ton of these. But this is a kind of a layered question because it's this, how to streamline a segment, but it says if someone is on a membership and agrees to said membership for 12 months and then takes advantage of the membership pricing and want to quit, even though they have a contract that says this person saying some people don't care that they sign contracts. So I guess what are your thoughts on these memberships to begin with, and then is there a way to hold people to them, or would you pursue them? Thoughts?
Yeah, so back in 2016, when I was at Jubilee, we created a membership program. We were one of the first ones, and it was very, very simple. And the key to making the membership make sense for us was to make sure that we are going to make money on the membership, even if somebody cancels, and that also we give them a lot of incentives to stay. So you kind of need to have the carrots and the sticks. So the carrots are, we would give people an anniversary gift. Every time we would have a special, any kind of special, like Botox $10 a unit. It would say Botox $10 a unit and members get a free facial. So every time the member would be reminded why their membership is so valuable. And then every so often, maybe on their 1 year anniversary or 6 month anniversary, whatever is the key drop off point, we would give them something else, like a gift or some upgrade. So I think that, yes, some people will just cancel and not care. They'll say, sue me, I don't care. But you have to structure your membership so that, let's say you forecast, it's all about the numbers, right? Let's say you forecast that 30% of people are going to do this nasty thing to you. So you have to make sure that you're making money with the other 70. So you would have you and your business consultant, or you and us, or you and whoever you work with to do this, would really make a spreadsheet of your memberships and the expected number of what's called churn. And then you would model it out and see what makes sense. Don't make your membership like, oh, you sign up today and you get 6 free cycles of cool sculpting your first month. So that if somebody wants to cancel, it doesn't really hurt.
It's such great advice, Sarah. And I think I don't know if you can see my face as I was asking you that question, but it's like you can't go after a patient, and you're not going to go after a patient for a couple $100. It's destroy your credibility in the market. One bad review is so costly. Having Sarah and her team write a letter, and now I've put someone in collections over set amount of 129, 279, whatever it is, your monthly membership just doesn't make sense to me. So I think the great advice there is keep people engaged, keep them happy by doing things. And Sarah, I also made me think, with employees, we call it a profit share. But we do an annual bonus, and it's typically in the end of February, early March. And because we've got our numbers from the year before, we're able to go through bookkeeping and really get, figure out where our numbers are. But by doing that, sometimes people get upset during the year, but they work it out with the employer. They come to us, they talk to us, they work it out instead of, because they know that there's an X amount of their money is holding on. So over the period of years, I think it has helped us to pay that way. And maybe it's quarterly for some folks, or however they may do that. As long as you don't tell us that we're not allowed to do it. But
Yeah, we're gonna have that conversation after this webinar. But no, all kidding aside, I think, yeah, you want everyone to be incentivized to be on your team, right? Your patients, your staff. So you want your patients to be incentivized to use the membership and to make them feel special every time you send them an email or they come to the office. So I think there are ways to make the membership feel appreciated. And the memberships are great in terms of practice valuations too. We work with a lot of private equity firms that acquire med spas. And when they do studies about people's financials and quality of earnings and all that kind of stuff, they're looking at how sticky the customers are and are there memberships and what percentage of customers are memberships. So memberships are great for that. And also employee retention is great for this. Every time we do a deal, people ask, okay, who are the key employees of this practice? How long have they been here? Have there been any issues? So if you have a big churn problem with your staff, just like if you have a churn problem with your membership or your clients, it always comes out. So it's important to get everyone on the same page and aligned in terms of how you're motivating them to stay.
yeah, and I would think if you're a solo practice or solo provider, those memberships are really, really good, because they're already trying to discount your deal because your name is associated with every patient. But now if you have those things, it's really got to add value. So it's a great thing to think about as we enter the twilight year, the sunset years. I saved my question. I won't say for last, but maybe because I want to ask you about a couple things about your practice as well. I wrote on here this Facebook. I notice here I didn't tag you, because normally I tag you and bam, you're right on it. And I know, because I know how to get you. But I didn't on this one, so you may have missed it. But I said, if I buy used equipment, can the manufacturer deny me parts and service? Like, this has to do with those recertification fees. We recently had a situation where we're having this problem with a handpiece on a used unit. The manufacturer is saying, oh, well, we have a software upgrade. Nobody else can do it but us. And once we do the upgrade, it'll fix your machine, but it's $10,000 to recertify it. Otherwise, we don't do upgrades. So I'm stuck.
Yeah, so yes, the manufacturers can deny service because there's no right to buy from any person, or there's no right to service if you bought a used device. So yes, the manufacturers can deny service. But if you can prove that they are practicing in some discriminatory way, or if there was something wrong with the device, and let's say you know about some problem with the device, and if word got out about it, the manufacturer would be would have a lot of sales issues. Maybe you could negotiate some kind of unique contract with them where you're not going to say anything, they're not going to say anything, and they let you get a reduced recertification fee or a free one. So it's not a great situation, but yes, the manufacturers are implementing these policies where basically if you buy a used device, unless you pay them more money, they're not servicing your device. And I don't think it's right. But those policies are difficult to fight.
Buyer beware.
Yeah, buyer beware. And the contracts for devices, like, please make sure before you're buying anything substantive, whether it's a device or your lease agreement with your landlord or an employment contract with someone, that someone who's knowledgeable in the area, like a lawyer or whoever your trusted advisor is, please make sure that the contract is reviewed, because it's so much more expensive to get out of a bad contract than to have a lawyer proactively review it. So with a lot of these different used devices and device contracts in general, just make sure someone reviews it. And they're negotiable, but very hard to negotiate once it's already been signed.
As always, terrific advice. Last question that just came in, I'm going to answer. How do I join the Facebook group? And are you able to share this webinar recording? Yes, we will absolutely share the webinar recording. They usually take us a week or so. businessofesthetics.org. You can very likely just search Sarah Schickman, and all the great both webinars that we've done together and podcasts will come up. And I think they're all worth a listen to. Some of them were a little more specific. Some of the questions I didn't get to today were like, what are the 5 things that I need to do if I'm a new business to not get in trouble? And I think Sarah and I literally did a podcast with 7 of those things for brand new. So I didn't, I hope that we were able to answer a lot of those within the context of what we did today. How do you join the group? Go to Business of Aesthetics on Facebook, type in Business of Aesthetics. We have a page with, I don't know, 1,000 followers or something. And then we have a group that has close to 6,000. Join the group. The page, all you have to do is like it and you'll get info on the page. The group, you have to answer a couple questions. Same as LinkedIn. A lot of great people. And Sarah is a huge part of our community, but one of our community as well. So there's a whole group there that have opinions, and take it with a grain of salt. Not everyone's opinions are terrific, and I think that's why we have lawyers and our own advisors as well. So it looks like they put in chat, the team put up in chat a couple of quick links to some of that stuff as well. Sarah, I want to just have you for maybe a minute or two talk about your program. You mentioned it at the beginning. You have somewhat of a membership program I think is absolutely fantastic, especially if you're a newer practice and you want to know what legal costs are going to cost you and put it into a budget and have some idea of those expenses, get started on the right foot. But would you talk about that membership program? And also, I know in the past you've made like a 15-minute a free consultation available to the Business of Aesthetics members. I'm hoping you'll still do that, but I want people to know how they can take advantage of it.
Yeah, definitely. So I'm a big believer in memberships, and I think that they help clients really get the full scope of the legal services that they need. And our most common membership is called our premium membership. It works out to only about $4.49 a month. And basically you have a bank of hours to use with our team, and you could use them for any questions that you have. And then that bank of hours also gets used to get you the custom documents that you need for your specific practice. So like that MSA agreement and contracts with your staff and any licenses and permits you need for the space. So we use the hours to get you fully set up or fully compliant. If, let's say, you're coming to us and you're an existing practice and you just want to make your paperwork and things better, or you want us to take a look and see. The other kind of benefit of the membership is we have a big template library. So if you're one of these do-it-yourself type of people, and I'm one of them too, you can just download some templates from our library for consent and protocols and employee handbooks and work on them yourself. So the membership comes with all of that. So that's the most popular way that people get started with us, and that's called our premium membership. And our website is lengialaw.com. We'll put it somewhere in this webinar. And then if you click on memberships, there'll be a link somewhere on that page to schedule that free 15-minute consultation. My email address is very long, so I'm not going to bore you guys with spelling it out. But once you schedule that consultation, we'll talk to you, and I'm sure we'll be able to get you on the right path.
And it looks like our team just put that up in chat, a direct link to the forms to get to Lengia Law, and also the phone number and the website. So it looks like everything you need is there in chat. We will have it again posted as part of this webinar. So team, thank you also the team at equa.com that puts this together for us, that hosts these. It's not easy to put together the webinar and make sure everyone has the right links to get on and had an opportunity to ask their questions, and we appreciate so much the work that you do. So thank you for the team at equa.com. Sarah, thank you again for just being a terrific part of our community. I have come to respect and value the information that you give us so much, and how genuine and sharing you are. And I love that you're part of the community, and I can only think that it makes you a better lawyer because you have people asking you questions in real life situation. You're part of the community. You're not outside the community. You're right inside the community. I love that.
Yeah, it gives me a lot of pleasure to help people like in real time. So I love being part of the community, and I love the marketing help that I've gotten as a client of Equa, like in terms of just helping me organize my marketing better, track things better. So I think there's a lot of value in this whole community and the different vendors that we have, and the advice that I've heard from med spa owners too. I think a lot of people maybe should be lawyers too, because people said there are some pieces of great advice on the Facebook group. So I'm always learning something new, and it's really fun to be part of.
Makes me think of Dr. Oprah when she was delving into that medical stuff. Well, thank you. And thank you for the testimony for Equa. If as part of this, those of you that join this webinar, special treat for you. If you want Equa to go through your web pages, they have a $1,500, what's normally a $1,500 consultation. If you join this webinar with Lengia Law and Sarah, they will do that at no cost for you. So they will do a full review of your web. You go to equa.com/MSM marketing strategy meeting and fill out some info. They'll take a look at your website. You get about an hour with them going through everything. Secondarily, go to lengialaw.com, and if you want, if you haven't already, fill out that time to spend with someone on their team. I would write a couple of questions down or things ahead of time and really make great use of that time. It would not shock me if you end up being a client of theirs. It looks like there's lots of different ways to do that. So I think one of the questions you may have with Sarah or someone on her team is, how can I best work with you? What's the size of my organization? Because if you're established and you're 15 years in practice, you already know a lot of things. You may have more of a project-based relationship, but certainly in the beginning, if you're not calling someone on her team every month, I'd be shocked. And if you're not, then you're probably not doing it right because you're missing things. So I would definitely recommend it. I only wish, Sarah, in 2007, I knew you, I probably saved years and years of money and mistakes, but I'm glad in the last few years we've had this terrific relationship. So happy holidays to everyone. It's December. Happy Hanukkah to those of you that are celebrating. It's almost over. Merry Christmas and happy Kwanzaa. And I hope everyone has a terrific holiday. Sarah and Lengia Law, thank you again. Everyone enjoy your evening.
Thank you.